at 9:00 a.m.
Your Honor, I'm expecting to be in jury selection on the 9th.
You gave me that option. All right, how about June 2nd?
June 2nd, yes, Judge. I'll be here anyway for another matter. June 2nd works.
Okay.
Yes, thank you, Judge.
June 2nd at 9 a.m. Bond is continued.
Thank you, Judge.
All right,
Great.
have a good day.
You as well.
Bye-bye.
You too.
Thank you.
State of Michigan versus Chance Clinkscales, case number 25S00127.
Tiffany Woods for the people.
Good morning, Your Honor. May it please this honorable court. My name is Jay Dallow, appearing on behalf and with my client, Mr. Chance Clinkscales. Mr. Clinkscales, can you please unmute yourself and state your name for the record?
Chance Clinkscales.
Thank you, sir. And we're proceeding today via Zoom. Do we have your consent to hold today's hearing via Zoom?
Yes.
Thank you. Your Honor, may we have a brief breakout with my client? May I have a brief breakout with my client just to review the offer with him? I think we'll have a resolution today, possibly.
Certainly, we'll put you in a breakout room with your client.
Thank you, Judge.
I will call the matters of Mr. Elroy Love. Case numbers 23FB1442 and 23FB1460.
Tiffany Woods for the people.
Good morning, Your Honor. Christina Costantino, appearing on behalf of Mr. Love. Mr. Love, can you please unmute and state your name for the record?
Elroy Jamari Love.
Sir, please turn on your camera.
I'm sorry, Elroy Jamari Love.
All right, thank you so much. We're here for pretrials in these matters.
Yes, Judge, I've had an opportunity to speak with my client, and at this time, he wishes to have these matters set for a final settlement conference.
Final settlement conference will be June 27th, 2025 at 9:30 a.m. with the jury selection on July 11th, 2025 at 8:30 a.m.
Okay.
And your
Thank
client is aware that after today, there are no further offers that will be made.
Yes, Judge, my client is aware of that.
Thank you.
Thank you.
We'll see you on June 27th.
Thank you.
State of Michigan versus Daquan Delane, case number 23S00369.
Woods for the people.
Good morning, Sarah Sallin from the Michigan Civil Criminal Litigation Clinic on behalf of Daquan Delane, who is present via Zoom. Mr. Delane, please state your name for the record.
Daquan Delane.
Thank you. We're here for adjourned pretrial. Last time, no counsel appeared.
That's right, Your Honor. I'm sorry. We're conflict counsel and I did not receive any notice of that hearing, so I apologize. We did receive notice and we are here today. I believe this is a pretrial and a bond violation. I haven't received anything in writing, but have been in contact with Ms. Woods. He does have a pending matter in 14A2 when there's a final settlement conference scheduled for June 4th. So we would respectfully ask for this to be continued until after that date.
By this, you mean the bond violation piece?
Yes, please.
Ms. Woods?
Judge, I would have no objection to that adjournment.
The domestic violence here, is that conditioned on that as well, or what are we doing with the pretrial?
Judge, considering that he picked up the new case, it's a new domestic violence case with the same victim. I'm waiting to see what happens with that PCC, to see how that case goes, to see if there's maybe a potential global plea offer.
It's a felony?
Yes, Judge, I believe so.
Is that correct? Is it a felony?
Your Honor, I'm not aware. I can look it up. The public defender's office does represent him in that. My clinic doesn't represent him in felonies, but we're only conflict counsel, so that's why we're representing him on this one. But Ms. Woods might know more because I haven't received much information about that one.
Let me look, Judge.
All right, thank you. If it's not a felony, I'm not gonna adjourn it for another misdemeanor past that misdemeanor. Just to start it first.
It was a misdemeanor, girl, civil.
And it's a misdemeanor. And it's just a pretrial, not a PCC, correct?
Well, this domestic violence, the case number I specifically gave you is the one that set for settlement conference on June 4th with jury selection on June 9th.
I see.
Yeah.
It is a misdemeanor, Judge. I
Thank you.
thought it was an ag, so my mistake there, Judge. As far as this case, Judge, let me look at my notes real quick.
And it's the same complaining witness in both?
Yeah, Judge, I didn't know if we were gonna do a global on that or not.
I'll put it to June 16th.
Thanks, Judge.
Thank you, Judge. What is that at 9 a.m., Judge?
Be at 9 a.m.
And that's for pretrial as well?
Correct.
Thank you very much.
And then bond violation, it's both for the bond violation and the pretrial. Hopefully we'll know more about whether there's an actual bond violation we can proceed on at that time.
Thank you, Judge.
Thank you.
Mr. Delane, I'll call you right after this. You can log off.
Okay.
State of Michigan versus Marlon Robinson, case number 25S00010.
Tiffany Woods for the people.
Good morning, Your
Good
Honor.
morning.
Assistant Public Defender Davy Lebo for Mr. Robinson. Mr. Robinson, can you state your name?
This is Marlon Robinson.
Thank you. We're here for a pretrial.
Yes, we're going to be requesting an adjournment today. We're looking to get the CPS report in this matter. I have requested it, did on the form that they provided, so I believe we should be getting it relatively soon.
I think that's the same thing you said last time you were here.
Last time Mr. Robinson was attempting to get it, that's proved to be fruitless. So now I've moved on to myself trying to get it, and that seems to be moving along, Your Honor.
Okay, thank you. June 9th, 2025 at 9:00 a.m.
Thank you, Your Honor.
Bond is continued.
Thank you, Your Honor.
You're welcome.
Your Honor, we're
Yeah,
ready
blessed
to
day.
resume. We're ready to resume on Clink Scales, Your Honor.
State of Michigan versus Chance Clean Scales, case number 25S00127.
Woods for the people.
Your Honor, thank you for recalling the case Jay Dallow on behalf and with Mr. Clink Scales. Mr. Clink Scales, are you back with us?
Yes, I am.
All right, thank you, sir. Your Honor, thank you so much for that time in the breakout session. Mr. Clinkscales, you and I have had multiple discussions on this case. Is that right?
Yes.
And you understand the prosecutor's offer, which is to offer you HIDA, which is the Homes Youthful Trainee Act, in return for your guilty plea to the charge.
Yes.
And you understand all of your rights regarding HIDA, regarding going to trial, and all of your trial rights. Is that right, sir?
Yes, I do.
Okay, I just wanted to review that with you, Mr. Clinkscales. Your Honor, my client understands that there's an offer by the people of HIDA on this matter, and my client does wish to avail himself of that offer.
Thank you. All right, sir, it's my understanding that you're gonna be pleading guilty as charged to a charge of the telecommunications malicious use with a domestic relationship. That is a misdemeanor. It carries a maximum penalty of up to 6 months and or $1,000 fine plus court costs. In exchange for your plea of guilty, the prosecutor would be providing you with a HIDA. HIDA is a first offender program that allows this to not be on your record if you complete all the terms of probation. Then it would not be on your record. Is that your understanding of the agreement, Mr. Clinkscales?
Yes, Your Honor.
All right, please raise your right hand to be sworn. You swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. All right, I'm gonna go with some rights that you have because this is what you want to do. You want to do this plea agreement, correct?
Yes.
All right, I'm gonna go with some rights that you have that you're gonna be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay?
Yes.
You have the right to have a trial by a jury, at which time you can call witnesses to speak for you. Excuse me, you can get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you. You have the right to be a witness for yourself, or you could choose to remain silent. If you did choose to remain silent, the prosecutor could not comment on it. In addition to that, you have the right to be presumed innocent unless the prosecutor can prove you guilty beyond a reasonable doubt. Do you understand those rights?
Yes.
Do you understand you're going to be giving up each and every one of those rights, sir? And you're not going to be having a trial of any sort.
Yes, I do.
Do you also understand that there's no automatic right to appeal this decision? So the decision that you're making today, in all likelihood, it's going to stick with you. You understand that part?
Yes, I do.
And if you were on probation, parole, or bond on March 14th, 2025, when this happened, you could be in violation of that probation, parole, or bond. Were you on one on that date that you're still on today?
No, ma'am.
And if you're not a U.S. citizen, there could be immigration consequences. Do you understand that part?
Yes, I do.
All right. To the charge of telecommunication services, malicious use with a domestic relationship, how do you plead?
Guilty.
Has anyone promised you anything other than what we just placed on the record to get you to plead guilty?
No.
Anyone threaten you in any way, shape, or form?
No.
All right. So on or about March 14th, 2025, did you make contact with somebody that was at 2849 Gulfside Road here in Ypsilanti Township?
If I did, I wasn't served the personal protection order. So I had no idea, but I believe no.
Okay.
Mr. Clinkscale, so in order to complete the plea, the judge is trying to establish a factual basis. Did you, the date that the judge provided is what this charge is about, that there was an aggressive telecommunications made. And so the judge found that date because that date is in the information on your case. It's in the discovery on your case. So was that March 14th, you said, Your Honor, right?
March 14th, 2025.
March 14th of this year, of 2025, there was a.
Oh, I'm
there
sorry.
was
Yes. Yes.
Yeah. Okay. So before he answers yes again, if Your Honor can ask him the question so he can respond yes to the right question. So
Do you want to voir dire your client? You can if you.
no, nope. I can do it, but let's give it another shot. You were doing great.
All right. So on March 14th, 2025, did you have contact with somebody who was at 2849 Gulfside Road, apartment number 41?
Yes. Yes, I did.
All right. And you called that person, was that Ajane Court?
Yes, it was.
You made a phone call to her? Or a text,
Yes.
or what did you do?
Phone call.
Okay, and what did you say to her?
I can't really remember because it was like months ago, but it was
Mr. Cleanskills, hold on one second. Your Honor, could you, or if the people can review what it was, and then so my client could
I
either
don't
agree or
actually
disagree?
get I don't get the police report. I only get the charging document. And
Madam Prosecutor, if there's something specific, we can ask him something general as though, was that something aggressive in nature, in order to satisfy the statute? The people?
Yes, Mr. Clinkscales, did you make threats to come over and snap on Anjane's neck? Because she did check in on you.
I believe I did. I think I did say that. Yes.
all right, I find that that is a malicious use of a telecommunications device. There was a threat of snapping someone's neck, which is a threat of harm. I find that there's a factual basis for the plea. It has been willingly and knowingly made. Are you satisfied, Ms. Woods?
Yes, Judge.
Defense satisfied, Your Honor.
Thank you. All right, is everybody available on June 9th, for a thing?
That is Wednesday. I'm sorry.
That's a Monday.
Jumped ahead. Yep, sorry, I jumped ahead in June here. Yes, available for sentencing. June 9th. Would that be in person, Your Honor? It can be done via Zoom?
On Zoom, correct.
It's on Zoom. Okay, yes, Your Honor.
All right, June 9th at 10 o'clock a.m. will be your sentencing, sir. You need to make and keep an appointment with the probation department. I'm gonna give you the phone number at this time. If you could please write this number down.
Okay.
Let me know when you have a pen or a device or whatever you're putting it in.
Okay, I'm ready.
All right. 734
734
483
483
783.
783.
No, 783 73
Oh, 7336.
36.
I'm sorry.
So 7336.
So 734 483 7336.
Correct. So you need to call them tomorrow after 9 o'clock and they'll schedule an opportunity for you to have a pre-sentence investigation report done. You getting that report done is a condition of your bond. It has to be done before you come back here next time. So please make sure you call them so you can get that done. And then we will see you back here on June 9th at 10 o'clock a.m., okay?
Okay, we'll do, Your Honor.
All right, thank you. Have a good day.
Thank you. Thank you, Your Honor. You too. Thank you, Ms. Woods. And Mr. Clinkscales will be in touch. Okay, sir?
Yes, sir. Thank you.
Thank you, sir. And happy Mother's Day to all the mothers, all the great moms out there.
All right,
Thank
thank
you.
you. Appreciate that.
There, you got it. Bye-bye.
State of Michigan versus Alexander Cronon, case number 23-00315.
What's for people?
Assistant Public Defender Davi Lebo, on behalf of Mr. Cronin. Mr. Cronin, can you state your name, sir?
Alexander Cronin.
Thank you. All right. We're
In
back.
general, we do have an agreement today.
All right.
Today, where Mr. Cronin will plead guilty in exchange for an agreement to a time-served sentence.
How many days does Mr. Cronon have?
That would be 9 in the Washtenaw County Jail. He did spend the past year roughly in the Oakland County Jail.
Whole year? Wow.
I believe was roughly that amount. Is that correct, Mr. Cronin?
Yes, it was 10 months with time served. I mean, with good time.
Oh, wow. Okay.
Well, can we have a breakout room, Judge, or with you, me and Mr. Lebo?
Certainly. a trial of any sort?
I do understand.
And you also understand that there's no automatic right to appeal this decision. So the decision you're making today, in all likelihood, is going to stick with you.
Yes, I understand.
And if you're on probation, parole, or bond when this happened, back in 2023, January 1st of 23, and you're still on that same one, you could be in violation of it. Were you on any back then, sir?
I'm not fully understanding the question. Could you rephrase that?
Were you on probation or parole back on January 1st of 2023?
No, I was not.
Okay. And if you're not a US citizen, you could have immigration consequences. Do you understand that part?
Yes, I do, Your Honor.
All right. To the charge of, and I don't think I said that out loud, you're pleading to domestic violence, which is a misdemeanor carrying maximum penalty of up to 93 days and or $500 fine. Do you understand that part?
Yes, I do understand.
All right. And to that charge, how do you plead, sir?
I plead guilty.
Anyone promise you anything other than what we just placed on the record to get you to plead guilty?
No,
Anyone threaten you in any way, shape, or form?
no.
All right. Give me one moment. I gotta. Find the complaint. This file is very thick, so. All right, here we go. On or about January 1st, 2023, between that date, and this is actually between that date and May 6th of 2023, were you at the vicinity of 7220 Homestead Road?
Yes,
And was there Sherry Lynn Fink present there?
yes,
And were you guys were you living together at that time?
yes.
And you were in a dating relationship, correct?
No, we were cohabitating.
Cohabitating, okay. And did you at some point in time make an assault or a battery upon Sherry Lynn Fink?
Yes, I did.
All right, what'd you do?
I hit her.
Okay. I find that there's a factual basis for the plea that's been willingly and knowingly made. Are you satisfied, Ms. Woods?
Yes, Judge.
Defense is likewise satisfied, Your Honor. Thank you.
How soon can the prosecution be ready for sentencing?
Excuse me, Judge, 2 weeks.
Okay, we can do 3. I'm not here on May, apparently court's closed on, that's a holiday. So June 2nd would work. Does that work with everybody's calendar?
Yes, Your Honor.
All right,
Yes.
all right, thank you. June 2nd, 2025 at 10. I don't need a long report or anything. He's getting credit time served, so we should be all set as long as she gets her opportunity to speak if she wants to. Okay? We'll see everybody then. Ms. Johnson, good morning. Do you still want to have him interviewed, or he's getting credit time served, or do you want that, or should we just bypass that?
We can do credit for time served. I can run his record and provide just this criminal history and driving record to the court.
Okay, thank you. So
You're
you don't
welcome.
have to contact probation or anything, Mr. Croton.
Right. Thank you.
All right, we'll see you back here on June 2nd at 10:00 a.m.
Okay. Right. Thank you.
Thank you.
I need to log out and log back in real quick.
Okay.
Thank you.
Yeah, there she is now. But Miss,
Liz is not in here yet.
yes,
So if you just want to let her know, it'll be just 1 second.
it'll be just one moment, Miss Mary Luce. So you know, we're waiting for the prosecutor to return. She has to sign out quickly, but it hasn't been quick so far. Okay, that's not how we work. All right, if you could hold tight for us, I'm gonna come back to that case as soon as the prosecutor returns. Do we have any Barnett matters I could do? Hmm. Hmm.
Is an understatement. He had a .283, over 3.5 times the legal limit. And even more important, and one of the more important elements is, and I highlighted this, it said that during the intake process, Jesse threatened deputies by saying, the next time we'll see if it doesn't turn into shots fired. Wow, that right there is what set the tone for me. But also at the sentencing, I had to establish a positive tone, give the defendant some encouragement. So his conduct was not only illegal, but it was atrocious based upon his conduct toward the officers throughout the entire process at the blood alcohol level. While he had some prior criminal history and some of it was close, he did have some successes on probation. But he did have one instance back in 2018 where he made it 4 days between one sentence and the next case. Then he made it 7 months between that and the next case. And in this file, he made it a little over, or just about a year and a half. So I had a defendant who was committing some repetitive conduct while not an overly extensive criminal history. It definitely gave concern to the court. So, but in that, I do know that I wanted to try to, I don't want to use the phrase shock and awe isn't appropriate. I wanted to change the treatment of the defendant and put him in a new place that would give him new objectives and opportunities to be successful. And
all right. Good morning, Taylor Gang. Good morning. make sure that if you are here, that you have hit the like button, that you have subscribed, and you dropped a comment. Let us know who in the chat with us today, who's hanging out. So today is going to be day 14 of the Karen Reed trial. Now, hey, Miss DB. Now, I didn't have court with y'all on Friday. I was hanging out in another chat on Friday because my son had an MRI. Thank you for everybody who sent good healing and positive vibes to us on Friday. If you didn't know, my son, he has special needs. He also was born with a really large tongue. He has like a genetic mutation. And so he's getting ready to have a tongue reduction in June, in about 5 weeks. So he had to have an MRI so that they can kind of look at the masses all around his neck and in his mouth. And so we went to have an MRI. So very low maintenance. Look, low maintenance for us. Very low maintenance appointment, but we still had to do it. So thank you everybody who sent out good positive vibes. Now I was hanging out in the chat. I was hanging out in a few different chats, just kind of listening and watching. And D Wood still in the building? D, you heard? Or you heard D? Because I got a question for you. We were out in the other chats and child, did the Karen Reed trial get messy on Friday or what? We had Buchanan on the stand who wanted to distance himself from Proctor, but really couldn't distance himself from Proctor. And so he really had very interesting testimony. A lot of things came through him, and he absolutely read the, text messages from Karen Reed, Brian Higgins, and I want to say he also read the message that Brian Higgins sent to John O'Keefe. Baby, what in the love triangle was happening? Okay, because what I got from those text messages is, one, baby, Brian was ready to risk it all. D Wood, I didn't appreciate how your comments kept getting blocked. I'm gonna have to leave the key, like you said. I'm gonna have to leave the key so y'all can get in the house, because I can't be having my folks being mistreated now. Okay. The reading of the messages were cringe as hell because he sucked at reading. He absolutely sucked at reading. But baby, Brian Higgins was ready to risk it all. He wanted Karen to make him a list of her wants and needs so that he could deliver. Okay. He wanted to be her man. Cue the music. I wish I had some music I could play, but yeah. He most definitely wanted to be Karen's man, but he understood that she had a man, she had a situation, and he was okay with playing his side role, his side part, until everybody got drunk and everybody in the same building. She absolutely slept with him, and it was not good. Anytime you leave your little boo house, your little sneaky link house, and they gotta text you thoughts, oh baby, it was not slapping. But what Megan say? Megan say, it never happened if the wasn't slapping. Okay, it was not slapping, and that's why Karen don't claim that body. She don't claim that body. That's why I don't go to Auntie and them. Hey.
You are unmuted.
Here we go, y'all.
Let's now open and make a seat.
All right, good morning. I came into 3 motions that I did not have when I checked email before coming to court today. So I'll hear you quickly on these. I've had a chance to read them. So, Mr. Brennan, I'll hear you. And let's today focus on the Bowden ones. We can focus on the other one later.
My motion memorandum on Bowden just iterates my objections continuously at sidebar, that not all evidence is admissible. Characterization of evidence is not admissible, and the defense should have the ability and intention to follow up with substantive proof if they're going to ask a question. it's not limitless. Bowdoin is wide parameters to ask the investigator about their state of mind, about the scope of the investigation, but it has boundaries of reasonableness. And my earlier objections about offering information that go into beyond Bowdoin, delve into third-party inadmissible evidence, those objections are what compelled me to draft this motion. And I can continue and will continue to object during the case, but once the questions are asked, if they're improper, the jury hears them, it inflames the jury. And without a basis and an intention to follow it up with substantive proof, the question should not be asked.
So the one point I want you to focus on, Mr. Brennan, is the specific evidence regarding materials that Sergeant Buchanan has not been able to look at.
You want me to?
Is that something we can do here in open court, or based on the protective order, is that something that should be done at sidebar?
Sidebar.
All right, why don't you come up, Mr. Jackson?
All right, they having a sidebar, so we can keep on talking, y'all. But I'm trying to tell y'all, Karen was trying to keep her skills up. Okay, Karen absolutely wanted to make sure she still had it and that she hadn't lost it doing all this, all this time with her going back and forth with John. She had let us know she was already dealing with somebody else. She had stopped dealing with him so she could deal with John. So she really had to, you know what I'm saying? She was just trying to see if she still had it. You know what I'm saying? And Brian nose was wide the fuck open. Okay. The man nostrils was open so wide he was catching flies. It was wide open, okay? Disturbing at that. And here they are sending pictures of drinks back and forth. Everybody need an AA meeting. Everybody need an AA meeting. She talking about Hennessy. He taking pictures of old fashions. I say these folks really need to see somebody. They really need to see somebody. I said, but yeah. Nah, I heard everybody talking about the kiss. Baby, they did a little bit more than kissing. She pulled up. To his house. Okay, this how strong Karen Mackin is. Okay, after doing all this back and forth, child's play with him in these text messages, playing on his top, Karen pulls up. You know what I'm saying? Let it go down. And then she leave. You heard me? She leave to the point. It had to be an awkward experience because he don't say nothing else but thoughts. She like, I don't have any. What thoughts? Thoughts about what? There are no thoughts to have, sir. Then what was telling to me too, though, was the fact that she texted him and said John's dead, and never text back. Now this whole time you've been trying to figure out how to steal John's spot. You've been trying to figure out how to get in his role. She tell you that he dead, and you don't hit her back to be like, "Oh, here goes my shoulder. Come cry on it." She done already sat here and told you all John business about how he really don't want to handle these motherfucking kids. So you really helping them, but y'all stressed out about it, and really they ain't either one of y'all kids, and you don't even want kids. Well, maybe you do want kids because maybe you would feel different about them if they was really yours. This whole time he asking you about the women that you didn't call him cheating on you with, asking if they banged. Did he bang her? Did he bang this person? Did he bang that person? And you mean to tell me that you text him and said John's dead, and he said nothing? Absolutely nothing. Oh, baby, no. Something is wrong, girl. And then he texts John, asking John, was he coming over too? Come on now. The setup is real. The setup is real. And don't get me wrong, I do think that Higgins. Okay, let me throw this out here, okay? Higgins most definitely wanted John to come over there because he wanted Karen to be over there. He still wanted to be around her because they sit up in this bar. He texting, and she ain't responding. So she most definitely like, dang, I ain't ready for it to be over. Girl, come over here. I'm finna duck you off in one of these rooms, okay? Maybe, maybe not. I don't know. I believe he was like, oh, come over here, come over, come over here. But when they got over there and John got into it with Colin, and Colin got the whooping on him. Oh, no. Colin and John got the fighting. I think John was putting paws on little Colin. I think he was putting paws on little Colin, drunk and all. And that's when Albert and Higgins jumped in a little bit. Now, I don't think Higgins really got to get his loins off because he wasn't really trying to make it obvious that he was messing with Kern. But I do think Albert jumped in and they got into a rumble. That's why he had his little eye. His little eye was messed up and his little arm was in that sling. You know what I'm saying? So I believe that's what happened. And when Albert jumped in, that's when they killed him. That's when John died. Okay. And they hid him down there in the basement for a while. They ain't tell the women. They hid him down in the basement for a while. And so the women absolutely didn't know what was going on until everybody got back to their house. And that's when what's her name husband? Jen husband told her when they got back to the crib. That's when she found out, when she was doing all that pacing back and forth. That's when she found out. And that's when she went upstairs and typed how long to die in the snow, because they had already came up with the plan that the snow plow hit him and they gonna put him out in the snow. You know what I'm saying? And then the next morning when Karen got up, Jen called an audible. She said, I'm gonna call an audible on the play. And I'm gonna tell y'all this what happened. We finna blame it on Karen. So she didn't go up to the door. She didn't go up and knock on that door because she hadn't had an opportunity to talk to them ahead of time. You know what I'm saying? She didn't want them to come outside with their story knowing that she was getting ready to, you know what I'm saying, come up with another story. She had already called an audible. That's why she had to center everything. You know what I'm saying? That's where I'm going. Yeah, they are calling the kids. And when they call the kids, they're going to cut the cameras off, D-Wood. Matt, Shay, that's his name. Matt told Jen when they got to the crib. He sure did. He sure did. And these detectives, they didn't try to figure out how the hell to cover this thing up. And they came up with a plan. And then Jen, smart ass, got out there and called an audible. And now they trying to fix her. They trying to fix her plan. And Carrie didn't know either. But Carrie didn't put two and two. Carrie didn't put two and two together. But Carrie can't be on the out in the community. Carrie know that these motherfuckers didn't play her. Carrie know that she done been lied to, and Carrie know that they killed John. But she can't be in the out. Her family can't be in the out on cancer. She done waited her whole life for this. So Carrie just like, fuck, we could have to just go with the plan. We just gonna go with the plan. Colin's knuckles was scuffled up too. He think he tough. You can tell him. You can say, see, that's what I'm saying. D-Wood, the fight started between John and Colin, but John was putting paws on Colin. He was putting paws on Colin, and so Big Brian had to jump in. Brian, B.A. What we gonna call him? We gonna call him I don't know. Brian Albert had to jump in and save Colin because Colin was getting the shit bit out of him by a drunk O'Keefe. And then Higgins was probably trying to break up the fight. He probably watched for a little bit, and then he was gonna go ahead and try and break it up. But the way he was, Big A, we gonna call him Big A. Thank you, Miss DB. We gonna call him Big A. See, Big A jumped in that fight. And when Big A jumped in that fight, you know what I'm saying? He you know what I'm they jumped him. That's when the jump happened. But I believe that John was putting them paws on LaColin. Because he was selling drugs in the neighborhood, is what was said. Yep. He came in there full of that liquor. He came in there full of that liquor. And when they hit the door, he was like, "Oh, and you? Let me tell you about yourself." That's what I think, y'all. So, how was y'all Mother's Day, everybody? Happy Mother's Day. Happy Mother's Day. Even though it's over. Y'all, they got me a massage. I went and got a massage yesterday. Oh my God. I went and got a massage. I came back. We ended up going to one of the grandmother's house, to one of the kids' grandmother's house. And she barbecued. And when I say I got there, I ate. I was so tired. They kept looking at me like, "Taylor, why you so tired? What you about to do?" I said, "Yeah, we finna go. Like, I'm just relaxed out here. I'm way too calm. I'm way too collected. You know, I had a magnificent day." And yeah. Yes, happy belated Mother's Day. Kim said it was great. That's what I'm talking about. Yes, happy Mother's Day. Yeah. People were so jealous about the massage they bought me. They talking about some, yeah, I hope I give me one. What? What you mean you hope you get you one? The day ain't even over yet. Aw. She said I laid around and the 12-year-old cook. That is beautiful, man. I wish my kids knew how to cook. But I tell you what, my daughter, when it comes to frying some bacon, oh my God, she make the best little bacon. She know how to make eggs and bacon. That's it. But I told her when I first started cooking, breakfast was the first thing that I started with too. But child, I was trying to find the
Let's
fried
bring in
chicken.
the jury. Will that take a couple of minutes, Paul?
Tragic.
Okay, thank you.
All rise, please.
Tragic. All right, y'all. Let's see what type of shenanigans we in for today. Okay, clearly I don't have a mouse. The kids broke the mouse. We ain't even gonna talk about it, but I'm gonna go ahead and reshare for us. I apologize for the delay. All right, let's see what's going on here. I had a busy afternoon too, y'all. So I'm gonna try to get us something queued up to watch on the break because I do think I got a call that I'm leading when they usually take the lunch break. So I will find us something. I will find us something to watch during that time. Hey, bro, I've been thinking about you. I saw those wanted posters and said, Lord, please don't ride in Memphis. I have 4. All of them can cook. My baby is 10. He do simple stuff like breakfast, but the other 3 are grandmas in the kitchen. Oh, teach mine. I'm gonna send my kids to your house so they can figure it out. Especially the oldest one. Baby, the oldest one, she don't make nothing but ramen noodles. The 12-year-old, she don't make nothing but ramen noodles. She's gonna be 13 in August. And then you guys, Samaj she just turned 11. But Samaj, she gonna be a cook. Okay. I had went out for drinks last Saturday. Not this past Saturday, but the Saturday before last. I went out to a little wine bar. I love a good wine. I went out to a wine bar, and so the next day, naturally, after getting up in the morning and stuff, I needed a nap. I went to sleep. I woke up, baby. Samaj never fed everybody. My son, the baby, herself. I say, Lord, thank you. Thank you. Thank you. Thank you for this one. She held it down while I took me a little 2-hour nap. They taking a long time to usher in the jury.
You are unmuted.
Hey. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court before the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
All right. Good morning again, council. Good morning, Ms. Reed.
Good morning, Julie. We appreciate your patience this morning. We're trying really hard to cut back on the sidebar conferences, so we spent some time this morning, hopefully paving the way for that to be able to happen. So we do appreciate your patience. I do have to ask you those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left Herrick Drive? Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research and investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here for the week? Everyone said no or shook their heads. Thank you. Could we have Sergeant Buchanan again, please? And Mr. Jackson, you can go to the podium.
Thank you, Your Honor. Sorry about that.
Okay.
Sergeant, I'll remind you, you're on the road. Thank you.
Good morning.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Good morning, Sergeant.
Good morning.
I'd like to ask you, just to start off with, at some point during the course of your investigation, did you become aware that a snowplow driver had reported having seen a Ford Edge being moved into a location in front of 34 Fairview sometime in the early morning hours of January 29th, 2022?
We learned about a plow truck driver. I don't believe his recollection was as you described, though.
Do you remember him mentioning a Ford Edge?
Yes.
Okay. And do you remember him saying that the Ford Edge had been moved? He had passed by, it wasn't there. At some point, he passed by again, and it was there, impeding his plow route.
Yes.
Okay. What is your best memory about when he said he believed the Ford Edge? Sorry, I guess a better way to put it is, when did he say he first saw the Ford Edge in place in front of 34 Fairview?
I don't remember exactly. I know it was during the middle of the night. My not adopting your narrative was the fact that he saw it being moved there.
Understood. I figured that. I clocked that as soon as I said it. He didn't see it moved. He saw it. He saw 34 Fairview without it there. Then about an hour later, it was there.
I believe so, yes.
Okay. Would about 3:30 in the morning sound right to you in terms of what he reported, in terms of the time that he saw it there?
It sounds right, but I'm not sure of the exact time. My report would reflect the accurate time.
Fair enough. Let me see if I can grab that report real quick. Let me ask this. Well, it's a very lengthy report. Instead of making you sit there and wait, let me just ask this. Do you remember him saying that he had first plowed the area free of the Ford Edge? In other words, first passed in front of 34 Fairview around 2:30 in the morning? Does that sound right?
I believe his dispatch time for the plowing of the roads that evening was 2:30, but I would have to look at my report.
That's fine. And then it was sometime subsequent there too that he saw the Ford Edge in place, maybe an hour later.
Sounds about right again.
Okay. Did you take any investigative steps when you learned about this snowplow driver to determine who, if anyone, might have owned a Ford Edge associated with 34 Fairview?
I did not know.
Did your investigation ever reveal that the Albert family actually had a Ford Edge at the time?
Yes.
I want to shift gears for a second to One Meadows, if I could, and ring video evidence associated with One Meadows. You testified that on direct examination that there was no video from Ring at or around the time 12:36 a.m. When Miss Reed's SUV returned back to One Meadows. You remember that testimony?
Yes.
You did receive a search warrant returned from the Ring Corporation in furtherance of a search warrant executed by Trooper Proctor, correct? Former Trooper Proctor.
Evidence was returned by Ring, yes.
And in addition to the actual video recordings, there was also an activity log that was returned associated with that time and that location from the Ring Corporation, correct?
There was a key log identifying each video that was provided by the time and date when the video was recorded. It's not an activity log per se for the account. It's strictly a key describing the video, telling you what time the video was recorded.
During the entirety of your investigation, was there any evidence uncovered at all that Ms. Reed had accessed the account information associated with that Ring account?
No evidence could be provided by Ring documenting that activity.
But there is evidence that someone had accessed the account through John O'Keefe's cell phone, correct?
I am not aware of that.
Are you aware that after John O'Keefe's cell phone was recovered by Massachusetts State Police, someone at Massachusetts State Police actually opened the Ring app on his cell phone?
Yes.
Who is the person who opened and accessed the Ring app on John O'Keefe's cell phone?
I'm not 100% sure.
I have just a moment, Your Honor.
Yes.
Would it refresh your recollection to take a look at a report, perhaps?
Yes.
May I approach?
Yes.
If you could take a look at that 3-page report and tell me if that refreshes your recollection. May I approach, Your Honor?
Yes.
Sergeant, having looked at this report, does that refresh your recollection as to who may have accessed that Ring app?
Yes, that report is authored by Michael Proctor, and it says that investigators accessed the Ring application.
Thank you. I want to show you one other document, if I could.
Thank you.
Thank you. I've just handed you what purports to be the search warrant return for the Ring, from the Ring company, correct?
I got to take a look through all of it.
Of course. Take your time. Thank you, Sergeant. Have you had an opportunity to review that document?
I have.
Does it indicate that in addition to several other files, there is a login session report that was produced by the Ring Corporation as well? It's highlighted on that page.
Number 4 is highlighted with one Excel file containing login session information.
Thank you. May I approach?
Yes.
Thank you. And again, just to make sure I'm very clear about this, nothing from the Ring Corporation suggested or intimated that Ms. Reed actually accessed any of that Ring account information, correct?
The information provided did not indicate that, no.
Thank you. I want to ask you a couple of questions about your testimony on direct examination related to your trip to the hospital and your observation specific to Mr. O'Keefe's right arm. You indicated that you saw bruising on his right arm in addition to the abrasions, the parallel abrasions that you described, correct?
I believe bruising is very similar to abrasion.
Okay, that's my question. Can we, Your Honor, can with the court's permission, can we show Exhibit 1? It's already been introduced. Is this a fair and accurate depiction of what you saw in terms of the condition of Mr. O'Keefe's arm while at the hospital, if not exactly like this?
Yes, it is.
Okay. What did you mean when you said you saw bruising on his arm? What were you talking about?
I actually indicated bruising on his right hand, the back of his right hand.
Okay, that fair enough. From his wrist, when I say arm, can we agree, at least for this purpose for the purposes of this discussion, that I mean from the wrist up to the shoulder?
Mhm.
Did you see any bruising from the wrist to his shoulder?
I saw exactly what's depicted there with the abrasions and lacerations.
Okay. You know what lividity is, correct?
I do.
Okay. Describe for the jurors what lividity is.
Lividity is the pooling of blood inside the body as a deceased individual falls or is positioned naturally with gravity. Blood begins to settle in the lowest portions of the body. If you're laying face down, it'd be your face. It also contours to the imprint or the force that's exerted on the body from below. If someone's deceased on TV remote control, you can see the remote control, the buttons underneath from the pressure.
So it's a bluish, purplish discoloration of the skin, not from an impact, but from the pooling of blood after the heart stops, correct?
That's correct.
Do you see an area at the upper arm that the skin looks discolored in addition to the abrasions that we see?
I'm sorry, I was looking at that one.
Oh, sure. I'm sorry. Yes. Right up toward the upper biceps, triceps area.
I see that area, yes.
Okay. Is that consistent with lividity rather than bruising?
I would not agree with that, no.
You believe that that's a bruise?
I believe that that's a laceration.
I'm sorry. I'm talking about the discoloration of the skin, the reddish purplish hue of the skin, separate and apart from the abrasion, from the abrasions or lacerations to the skin. The discoloration. Do you see that discoloration or no?
I do not know.
You do not?
I do not know.
Okay, we can take that down. As you sit here today, you're not suggesting that you saw bruising from the wrist to the shoulder on John O'Keefe's arm?
Nothing that stood out to me.
Okay.
I observed lacerations and abrasions.
All right, thank you. I want to shift gears one more time and ask you about your trip to Dighton and the seizure of the SUV. You testified that you seized the SUV somewhere, I think your testimony on direct examination was somewhere around 4:15, 4:17, something like that, correct?
Yes, sir.
Does 4:12 sound like it could be a reasonable time that SUV was actually seized in Massachusetts State Police custody?
It could be reasonable. I'd have to refer to the video evidence that, and then also the exact time that we advised the defendant that we are going to be seizing it. I guess it could be argued that that's when it was seized. Even we had the intent to seize it right there.
Right. took the key fob, went outside, had a, pardon me, had a tow truck driver actually put it onto the back of a flatbed. Ultimately, it was transported, correct?
Correct.
And you became aware at some point that there was video evidence, you just referenced it, video evidence of that, I'm going to call it seizure process. Is that right?
Yes.
And that video evidence had a timestamp on it, correct?
Yes.
Okay. You're also aware, as the supervisor of Michael Proctor, that he swore under oath in multiple affidavits in support of search warrants that the SUV was seized at 5:30 p.m., correct?
Yes.
And you knew at the time, because you were actually there, and you knew when the vehicle was seized, that stating under oath in an affidavit that it was 5:30 p.m. and not 4:12 p.m., that was a false statement, correct?
There's a discrepancy in time there, yes.
Did you take any action, you yourself as a supervisor, did you take any action to correct that false or misleading state? Let me ask it a different way. Did you take any action to correct that time to the accurate time of 4:12 in any of the affidavits that you became aware of?
No, the actual time of the seizure through the video, we learned much later. So the approximate time, 5:30, although inaccurate, I did not take any action to correct it, no.
And you received that video as a production from the defense. You did not have access to that video, correct?
Yes.
And so at the time that Michael Proctor actually wrote and drafted these affidavits and swore to them under oath, he did not know that a video existed, correct?
Objection.
Sustained, you have to word it differently.
Sure. At the time that you, let me ask it a different way. At the time that you reviewed his declarations under oath, you did not know that a video existed.
No, we did not know.
If I may have just a moment, Your Honor.
Sure.
I want to ask you about something that was brought up on direct examination. Sustained findings as it pertains to you. You've already talked about the fact that, Sergeant, you're a supervisor and we're a supervisor back in January of 2022 moving forward over Trooper Proctor, correct?
Yes.
Generally speaking, as a supervisor, your job is to properly and professionally supervise, show some authority over those in your charge. Is that right?
Yes.
Michael Proctor was in fact a trooper in your charge.
Yes.
And you would agree that your supervision has a direct impact on the character and quality of the subordinate investigators that you supervise.
Yes.
The whole point of having supervision and a chain of command is to establish a certain amount of, for lack of a better phrase, quality control of the subordinates.
Yes.
That would also include quality control over the subordinates' investigations.
Yes.
On August 17th, 2022, you were in a group text with the following individuals: Michael Proctor, Trooper Kukowski, a lieutenant named Fanning, and a trooper named DiCicco, D-I-C-I-C-C-O, correct?
Yes.
Mayor Pro Tem.
Yes.
I'm handing you a document. Can you tell me if you recognize that document?
I recognize parts of it.
You saw that document on direct examination. I think you were shown the same document, correct?
It was different parts of it, but same. It's inclusive of within this document.
Okay. Let's start with this. You indicated that you did not see Michael Proctor's name on that document, correct?
Correct. His name is not on here.
But you do recognize that as being reflective, accurately reflective of the text chain that you were on August 17th, 2022, that group chat.
Yes, sir.
I'm going to do this a little bit backward, but bear with me. You do see the name Kukowski, correct?
I do.
You do see the name Fanning, correct?
I do.
You do see the name DeChico, correct?
I do.
And you do see the name Buchanan, correct?
No, it's misspelled, but I know they're probably referencing me.
Okay. The only other text or person texting on that chain is a code, a lengthy, almost like a URL code with no name, correct?
Yes, you're right.
And
Yes.
the only person that I didn't name, whose name I did not read off, it's obvious on that document, is Michael Proctor, correct?
Correct.
So deductive reasoning tells you that that is the code is Michael Proctor. Is that right?
I would agree with you, yes.
Okay. In that text chain, it starts with Trooper DeChico sending a photograph, correct?
No.
May I approach?
Yes.
You can turn to page 2683, please. Do you see a photograph there?
Yes, I do.
Okay. Fair enough. There were some texts between and among the group that preceded this photograph, correct?
Yes.
I want to start on this date, August 17, 2022, with this photograph. This photograph was sent by Trooper DeChico to the group, correct?
It possibly appears that way. I really can't. I mean,
Your Honor, with the
Yes.
court's permission, I'm not sure this document has been marked. I'd like to have this marked and
Sure,
admitted.
we'll mark it for ID.
I'd actually like to have it marked and admitted. There's certain things I'd like to show.
What's Cornwall's position on that?
I have no objection to admission, but not in this form. It needs to be redacted.
Can you do it?
What I intend to do, I can do with one photograph. If I may have a moment with counsel.
Okay.
May I just a second?
Thank you.
Your Honor, with the court's permission, I'd like to publish just one page of what's been marked for identification. I'm sorry, I would ask that it be marked, the entire document be marked for identification.
You're gonna need this.
It's exhibit FF for ID.
And with the court's permission, I would ask to display or to publish page 2.
Okay, y'all, I had no idea what the hell just went on, but let me get us back shared. Something happened with our stream. Life is so rough. Let's see. Buchanan. And off of mute. And I'm gonna share again. 1 second. Now he don't remember shit. I'm gonna rewind it a little bit.
Trooper Proctor, Michael Proctor.
According to this document, yes.
Before it's admitted, please.
It's been redacted.
Exhibit 116.
May I?
Yes.
Thank you. So we're talking about the same thing, Sergeant. I've just handed you a page that's been marked Exhibit 116. Do you recognize that as being a copy of one of the multiple pages in the document that you're holding that's been marked for identification as FF?
Yes, sir.
Okay, if we could publish that single page, please.
Okay.
Is that a photograph that was sent by Trooper DeChico to the group?
According to this document, yes.
Who is depicted in that photograph?
The big story, Mr. David Yannetti, criminal defense attorney.
Do you see that person in court?
Yes, I do.
Where is he seated and what is he wearing?
He's seated right there wearing a blue tie and a dark suit, white shirt.
Thank you. We can bring the lights up, Your Honor.
Okay.
In response to, and going back to the multi-page document FF, in response to Trooper DeChico's photograph that he sent to the group, you responded to that photograph, did you not?
Yes, this document indicates so, yes.
And you responded by laughing at it, correct?
That's what it says, yes.
Well, that's what it says, or that's what you did?
I don't remember.
Trooper Proctor then, former Trooper Proctor, Michael Proctor, then responded, correct?
That's what it says here, yes.
And he responded to the group, funny, I'm going through his retarded client's phone, correct?
That's what it says, yes.
Michael Proctor then responded again. Is that right?
Yes.
He wrote, no nudes so far, correct?
That's what it says, yes.
Michael Proctor responded yet again. Is that right?
That's correct.
And in reference to Mr. Yanetti's photograph, he wrote, I hate that man. I truly hate him. Correct?
That's what it says.
There's a trooper by the name of Moore, M-O-O-R-E, correct?
There is.
And he disliked Trooper Proctor's phrase, his statement, no nudes so far, correct?
That's what it says.
Did that indicate to you that Moore was disappointed that Trooper Proctor, Michael Proctor, had not found naked pictures of Miss Reed as yet?
I don't know what that indicated for Mr. Moore.
And then you responded to the phrase, funny, I'm going through his retarded client's phone, correct?
I acknowledged that text message being sent.
You acknowledged it by liking it, correct? With a thumbs up.
I acknowledged it by responding with a thumbs up emoji.
The fact is, Trooper Proctor told you, his supervisor, in this series of text messages, that he was going through Miss Reed's phone. Is that right?
Correct.
And he also informed you, his supervisor, that he was going through her phone looking for nudes or naked pictures of her on her phone. Correct?
He did not tell me that he was going through naked pictures, for naked pictures through the phone.
He wrote, no nudes so far, right?
That is what is written, yes.
What did you think he was looking for when he wrote that phrase?
Naked pictures, fool.
I don't know what he was looking for.
What would be a reasonable interpretation of what Michael Proctor was looking for when he wrote, no nudes so far?
I don't know.
Motorcycles, handbags, pair of shoes, or naked pictures of Miss Karen Reed?
His mission was to go through the phone to look for digital evidence that's related to the crime. The fact that he wrote no nude so far, I cannot comment on.
You cannot comment on, or you don't want to comment on?
I don't know what he was looking for in that specific time.
You certainly did nothing. You took no action to stop him from potentially looking for naked pictures of my client, correct?
That's correct.
In fact, last week you testified that in your view, Michael Proctor handled himself in this investigation with integrity. That's what you said, correct?
That's correct.
Do you stand by that testimony?
The investigation was handled with integrity and honor.
Do you stand by your testimony that Michael Proctor conducted himself during the course of this investigation with integrity?
Yes, I do.
He also called her retarded, correct?
That is what's written.
That's what's written? That's a very passive way of saying it, Sergeant. That's what's written, or that's what he wrote?
That's what he wrote.
And that's what you read?
I have no memory of reading that. I acknowledged him going through the phone on my Apple Watch. I have no memory of him writing retarded on a text message.
And you'll agree that that is one of the most vile and insensitive and incendiary terms one could use in modern society. Retarded, correct?
That is correct.
And in fact, through your response to that vile phrase, you encouraged it because you liked it with a thumbs up, correct?
Objection.
Sustained.
Did you encourage that statement by Michael Proctor by liking it with a thumbs up?
I don't know if it encouraged him, but so I cannot speak to
But
that.
that's what you did.
I acknowledge the text message being sent.
I want to be clear. These text messages were sent to you by your direct report, by your direct subordinate, correct?
That's correct.
And there was even someone on that text chain who was more senior than you, Lieutenant Fanning, right?
That's correct.
Michael Proctor was both your partner and the lead investigator on this case when he wrote that, correct?
He's a subordinate, and he was the case officer.
This thread, text thread, contains communications between a subordinate, the person you call the case officer. By the way, let me ask you another question. Did you ever, during the course of the investigation in which you were a part, the sustained findings, the internal affairs investigation, did you ever review Colonel Noble's determinations about your subordinate, Michael Proctor?
Objection.
Did you review them?
No, Your Honor, I did not.
What would Colonel Noble call Michael Proctor's title in this case? You think he'd call him the case officer or the lead investigator? What is your experience with Massachusetts State Police in that regard?
Objection.
Sustained.
Notwithstanding the fact that a subordinate was on this text chain and a supervisor to you, was Lieutenant Fanning one of your supervisors?
Yes.
Notwithstanding the fact that a subordinate was on this text chain and one of your supervisors was on this text chain, you felt comfortable enough within this group of law enforcement to actually like when the subordinate refers to a suspect as retarded, correct?
I acknowledge the text message with a thumbs up emoji.
Do you believe that? Well, let me ask you another question, a predicate question. You were also comfortable enough with that text chain to receive information that your subordinate was looking for naked pictures on a suspect's phone, a woman, no less. Correct? You took no remedial action against Trooper Proctor for that, correct?
No, I did not. No.
Do you believe, as you sit here, that that was a misuse of power and authority by a Massachusetts State Police officer?
By myself or
No,
somebody else?
by Michael Proctor.
Misuse of what?
Misuse of authority and power to go through a suspect's phone, to get her phone using the authority and the power vested in that officer by the community members. That's the power that you derive, correct? You work for the public. Would you agree?
Sustained.
Do you believe it was a misuse of his authority and power to use Massachusetts State Police authority to go through her phone and look for naked pictures of her?
Objection.
Sustained.
Do you believe it was a misuse of authority or power to go through her phone and potentially look for nudes?
Objection.
Sustained.
Let me ask it differently. Did you think his text was appropriate?
I don't remember reading that text.
As you
So
sit here now, do you think that text is appropriate?
no, it is not.
Do you think it's professional?
No, it is not.
Do you think it shows integrity?
That text message does not show integrity.
Do you think it shows honor? A word I expect you hold dear.
That text message does not show honor.
On October 15th, 2022, you completed a performance review of Michael Proctor, correct?
That's correct.
Specifically, you were asked to rank his, quote, oral and written communication skills, end quote, correct?
Correct.
That's part of an overall evaluation and performance review. Is that right?
Yes, overall 90-day quarterly annual review.
You were specifically asked to rank whether he effectively would whether members, your subordinates, would effectively communicate with others, both within and outside the department, in oral and written form, correct?
That's correct.
And you rated him as exceptional, a number 4 rating out of 5, correct?
That's correct.
You actually went on to write and comment on Michael Proctor, and you wrote, quote, Trooper Michael Proctor displays professional demeanor, composure, dignity, and respect during the performance of his duties, and especially during his interactions with the public. This is seen during interviews with witnesses, suspects, as well as victims and their families, end quote. That was a statement you wrote about Michael Proctor, correct?
That is correct.
And this is after the text chain that we've just been talking about, where he calls Miss Reed retarded and references looking for nude photographs of her, correct?
That is correct.
Was your statement in that evaluation true or false?
It was true.
You knew Michael Proctor's proclivities, obviously. He told them to you, correct?
The term proclivities, what does
You
that mean?
knew what he tended to do, what he wanted to do through his own comments, to look for nudes on a woman's phone, correct?
Objection.
Sustained.
You were aware, sir, that he had received evidence in a case, evidence that doesn't belong to him, belongs to the Massachusetts State Police, at least at that point, correct? The cell phone.
I was aware that he received a cell phone, yes.
And he used that power and the authority to go through that cell phone and look for nudes of my client, correct?
Objection.
Sustained.
During the same course of your evaluation, you were also asked to evaluate his investigative ability, correct?
That's correct.
You rated him the highest standard in the Massachusetts State Police, outstanding, a 5, correct?
That's correct.
And you went on to write about Michael Proctor in the commentary below that rating to justify it. Is that right?
That is accurate, yes.
You wrote, quote, Trooper Proctor has had a high-profile caseload with a lot of eye and pressure from external sources during the first day of the investigation. He handled himself and all the case with utmost professionalism and competence. He is able to investigate his case thoroughly and with strict integrity, end quote. Correct?
Which quarterly review was this?
This is the same one, October 2022. Is that right? Those are your comments.
That sounds very accurate. I just was not sure which quarterly review that was for.
Professionalism.
Yes,
You believe that he acted in accordance with the highest standards of professionalism?
during his 90-day performance, yes.
And you didn't just say he displayed professionalism, you said utmost professionalism, correct?
Yes,
Competence? Do you
Yeah.
believe he displayed competence?
Yes,
And not just in integrity, but he conducted himself, as you put it, with strict integrity. Is that right?
that is correct.
Did it show integrity in your view when your subordinate Michael Proctor called Miss Reed retarded?
Objection.
I'll allow that.
I believe that as a U.S. citizen, he has the right to comment. That's his First Amendment right. We uphold the Constitution, and it's unfortunate, unprofessional what he said in the private text message communication. He might have been voicing his frustrations. I cannot speak for Michael Proctor. It is unprofessional and unfortunate that he said that.
This was not, Sergeant Buchanan, a private text message conversation. This was with his boss and 4 or 5 other individuals, one of whom was your boss, correct?
Correct.
This was a communication intended for and received by members of his unit in furtherance of his investigative authority, correct?
It was amongst members of the unit.
He was updating his boss about what he was doing in furtherance of the investigation, going through her phone, correct?
No, I would disagree with you on that. This was a group chain, text message chain that we were discussing private matters in our personal lives.
Private matters, including going through Miss Reed's phone?
That is unfortunate he shared that on that group text.
So in other words, to the public, he holds one face in private conversations with you and your colleagues within the unit. He shows a completely different face, private face, correct?
Objection.
Sustained.
You said that you believe that he has a constitutional right, a First Amendment right, to call Miss Reed a suspect in his official investigation, in his official capacity as a Massachusetts state trooper, to call her retarded? That's your justification?
Objection.
Sustained.
Do you justify his statement, that vile statement?
I do not know.
Do you think it's appropriate, given the fact that he has a First Amendment right to say whatever he wants?
No, I do not.
Do you think there actually might be members of the community, parents, siblings,
Objection.
children?
Mr. Jackson, I'm going to exclude that question as argumentative. Move on.
You wrote in your report, if I may have a moment, Your Honor, you wrote in your report about his conduct. He shows composure, dignity, and respect during the performance of his duties, and especially during his interactions with the public. He has a duty to the public, to the community that he serves, correct?
Yes, he does.
Just like you have a duty to the public and the community that you serve. Is that right?
That is correct.
Do you think community members might take offense to the use of the
Objection.
word retarded?
Sustained. It's argumentative again, Mr. Jackson. Please don't do that.
He didn't just put it, that derogatory comment. He didn't just put it, or he didn't just say it, correct? He talked about the First Amendment.
Objection.
Sustained.
I'm not finished with my question, if I could.
All right, so just ask a question.
Sure.
No comments first, okay?
My question is, did he just say the word, or did he go further than just saying it?
Objection.
Okay, we've gone through this. Move on, please.
The fact is, Sergeant, you put it in writing and you liked it, correct?
I acknowledge the text message. I never saw the vile term.
Your Honor, may we approach it just very briefly for a scheduling issue?
Okay, jurors, feel free to stand up and stretch.
Yes, yeah. I think that he is doing a lot of belaboring. I think he got the point across. And that's the only issue that I have with AJ sometimes. I think that, and and it may be because Bev, as Shay mentioned, Bev does hinder a lot of what he wants to get out. So the things that he can get out, he really hammers in on it. But it's like he's already made the point, and I think when you make a point and it gives the jurors that wow moment, like when he said, "Oh, I said that he worked with integrity and honor." Okay, so was this honorable? No, you received these messages, XYZ. You know what I mean? I think that he had that wow moment that would have remained memorable in the jurors' minds. But as he continues to go on, like it starts to fade. And then people kind of start to clock out because it's like, I know that this man received these text messages. I know what the text messages say. I know who was all a part of the thread. I know what he acknowledged. I hear him on the stand. I hear him try and justify it on the stand and let me form my opinion. I think AJ got to know when to let go. He got to know when to let go.
Should have given you a break before this, but I thought that was going to be quick. Why don't we take the morning recess and we'll take.
Court all rise for the jury.
And we'll please go back to work.
Yeah, I think he'd been up there a little too long too. I was in and out on Friday, and so I'm pretty confident that he was up there all Friday. We had a late start today, but we are going all the way until 4:00. Until 4:00, 3:59 if you're looking at 3:58 if you're looking at Bev watch, because she's gonna shut it down. She's most definitely going to shut it down. So yeah. Yeah. Just trying to get my little work created. We got a little action going on in this short break. All right, let me see if I can get us in a quick little docket watch while we wait. All right, Raul is sitting in for Judge Fletcher, so we can go hang out in there for a little while. And we'll be back when Karen returns from break. Oh, okay, wait a minute. This isn't the right one.
She had external hymenal tissue, Judge, and so she also journaled her, I guess however you want to term it, she chronicled all of the people that she was sexually active with. Now the state's moved to try and keep that journal and those entries out of the case at bar, but one of the important points is when the loss of that hymenal tissue corresponds to the entry in that journal when she first discussed his having penile vaginal sex. Moreover, Judge, there's also an issue. The state is trying to prevent an allegation that the complaining witness has made against a childhood friend for excuse me, I can't breathe. Some number of years that involve allegations of sexual assault, but this is when they were 6 years old. And so they're also trying to keep that out. But in any event, and by the way, we mentioned before that we need to have a hearing on that motion in limine. And I don't know if you want to do that with the trial or potentially before the trial, given the complex number of factors that have to be considered in making a determination as to whether some of these matters will be allowed in or not.
Whatever we do, we got to fast track this.
Absolutely.
Because of the nature of the crime, and we're moving on 3 years, which is far too long for this case, this type of case, which the legislature has placed as a primary importance on trial docketing. And
Judge, if at all possible, I'd ask that this case be specially set because we have subpoenaed people so many times to show up, repeated subpoenas, and also
But you're ready.
Yes, we're ready.
State's been ready, Your Honor.
Well, then let's preferably set preference it as a number one case. When can we do it? From my coordinator.
Judge, we have special studies up to the summer. We could possibly do it at the very end of August or beginning of September.
How about beginning of September?
That'll work.
All right. And like a week before that, we'll set it for pre-trial motion hearings if necessary, or we may take it up during the course of the trial, depending upon what the circumstances are and what the parties wish to do.
So the only issue with regard to at least
you want money now for
yes
for prep.
Yes, Your Honor. We have this, I believe it's been filed, but it's an affidavit of indigence.
What are you asking?
So we
I have a motion in limine. That's not it. What are you asking for? Do you have something in a motion, written motion for monetary need?
No, for monetary requests, we do not yet.
All right, let's put that in a written motion and then we'll let you add anything to it in a hearing, but let's we have this now set. So we're talking about, we're in May, June, July, August. Okay, you got about 3.5 months.
Yes. The only issue with regard to the, I guess it'd be a 412 hearing, for some of these alleged prior incidents that the complaining witness has journaled about, is again, some of these journal entries correspond to a physical change associated with the complaining witness, specifically the loss of that hymenal tissue, that external hymenal tissue.
So and tell me what the statute says about sexual act with a child younger than 14, about whether the hymenal tissue is a necessary element of the offense.
No, Judge, the allegation isn't that it changed with regard to
just make it clear on the record.
Okay, so we allege obviously that it would have been impossible for the defendant to have engaged in the alleged activities prior to a date certain established within her journal, where she indicates that she engaged in sexual activity because her mother was caring for her birth defect up until the time that she engaged in sexual activity as reported by herself in her journal.
I know you've read the indictment. It's alleging 3 different types of felony acts within the statute, causing his sexual organ to contact or penetrate the mouth of the complainant. Where is that a part of?
As far as the mouth, Judge, it's not.
Okay, then that has nothing to do with your argument. Number 2, causing his sexual organ to contact or penetrate the sexual organ of complaint. What does contact have to do with it?
Or penetrate.
What does contact have to do with it? Absolutely nothing, right, with your argument. Okay, but I see the penetration point. I'm just saying there are variances and they are pled in the disjunctive, which means either way is you're on notice that they're going to attempt to, they're alleging both ways, and we just be one way may be the only way that is sought.
That the
third way.
The complaining witness articulated these allegations up to and including the penetrative issue, Judge, is obviously relevant to the other allegations in the indictment.
Okay. The arguments, forget it. What we're talking about is what's been alleged, what you are on notice that the state may be proving. That's what's only issue right now for me. Finally, the other way is intentionally or knowingly causing his finger to penetrate the sexual organ. How would that apply in your argument as well?
That would also result in the loss of hymenal tissue, the external nature of which is not, we're not saying that.
You know the definition of penetration of the vaginal area under law?
Yes.
It doesn't
require.
It doesn't require that.
It does.
All right, thank you. All right, anything else? I think we noticed not what the potential aspects could be, but what's necessary. And necessary can be met without having to deal with any of your issues, and unless the state is going to try something different, then we'll deal with it then. But you're on notice there. You have been placed on fair notice for years on what they are alleging, which are methods that can be proven as alleged in this case, which do not intercept or interact with your argument at all. So let's just move on with what is provable realistically under law. If something comes up, we'll take it at the hearing.
The statements of the complaining witness, Judge, are what are in issue.
Well, that goes to something that's always in a trial: credibility, how much weight and credibility to be given by a jury, and let the jury deal with that. Okay, I'm not going to prove that point up for them. We'll see how that plays out. I'm just worried about the issues that the state has been placing you on notice in the disjunctive. You've been placed on notice those areas. If they have to come up, we will take them up at the time. It's not necessary right now. They can prove their case as alleged without having to deal with your argument. And all indictments tend to be alleged disjunctively and also in a general fashion. And if we had hearings on what could happen specifically, if this is every case, we'd never be able to get to trial. So we'll deal with it in those rare cases that it becomes an actual issue. But I don't see it at this time. So we're going to move forward. Let's get to trial. Everybody sounds like we're ready, willing, and able, and let's move forward. This is a case that the legislature says needs to be fast tracked. So it shall be. What's the date?
September 15th.
Got it, everybody? September 15th. And special set first. Thank you. All right. Anything else? Marcus, anything else on this?
No, Your Honor.
Thank you.
You
All
have
right.
a hard copy of this affidavit.
No, I don't think
Okay.
we need a hard copy. You want to just make a copy?
Sure.
Yeah,
That's
just
good.
email me a copy.
Anything else on this? Anything else? Anybody? Yes, no? All right, we are in recess till 1:30. Thank you. Very good.
Always.
Yeah, Shay, he was not trying to hear it. He was not trying to hear your argument is moot. Put it in front of the jury. We're not, which is that was crazy anyway. And I agreed you would. If she was writing about it in her journal, it was happening. But he's been in jail for 3 years, so.
Possessing any firearms or any weapons. While you're on bond, you will also be prohibited from drinking any alcohol or any controlled substance that you do not have a prescription for. And you're also going to be ordered to undergo random urine test. Okay. I do see that you were also charged with the offense of possession of a controlled substance. And I see that the bond conditions on that one requires you to do urine tests. So Ms. Garcia, UAs, but he's going to pay the UAs because of the court upstairs. So it'll be defendant paid. All right, Mr. Leija, these conditions of bond are going to remain until this case is over with. I am going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, you are going to need an attorney to represent you on this case. I see that your other case was rescheduled to 6/25 for you to get a lawyer. So we're going to reschedule your case for the same day, June 25th. Now, Mr. Leija, if you do get a lawyer, just have that attorney contact this court before the next court date. You, sir, do not have to come back to court. You let your attorney take care of your case. However, if you do not have an attorney by the next court date, you will have to return to court. All right, sir, do you have any questions on anything that I mentioned to you? All right, right behind you, the table, my preacher also go with her. Sounds conditions, have a seat, we'll reset your case. Millie, page 10, Leija, THA. All right, come on up, Ms. Capillo. Come on up. We got our interpreter here. And let's see here. Yes, Mr. Martinez Delgado. And Ms. Anthony, this is Martinez Delgado, but it's not for PC. But there was a 2B one. Any cause number? Yeah, please. You're Argenis Martinez Delgado. Hi, Mr. You're here with your attorney. I just wanted to inform you, sir, of what you are being charged with. You are being charged with the offense of assault of a family member. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. I see that this was an offense that was alleged to have occurred on June 28th of 2023. That's almost 2 years ago. There's a individual by the name of Gamboa Francis that's accusing you of this offense. I see that there was an investigation that was being done by the Harris County Precinct 5 Constable's Office. I see that they were, sent over to a residence in Katy. They met with Gamboa Francis, and Gamboa Francis told the officers that you were her husband and that she's accusing you of assaulting her. Okay. So the officers went ahead and did an investigation, and they contacted the district attorney's office, and charges were filed against you. Now, those charges happen to be out there all of this time until it looks like you posted a bond in Fort Bend County. Was he arrested on Fort Bend? Did he get detained in Fort Bend and they found this warrant?
Yes, sir.
Okay.
Got pulled over for speeding ticket.
Okay, they found the warrant? Yeah, okay. All right, sir. So I do see that you posted a bond out of Fort Bend County and were released on bond. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. Now, Ms. Anthony, do you see this case, Martinez Delgado?
Yes, Judge.
Do you know if anyone from the state has had any contact with the complaining witness?
Yes, Judge, they have.
Okay. Is she requesting any conditions?
Let me check, Judge. Yes, it looks like residency restriction, no contact.
Now, did they contact the complaining witness recently?
This morning, Judge.
Oh, this morning. Okay. Were you aware of that?
I was, yes.
Okay. And do you know, I'm assuming, I see that in the to be warned, they were husband and wife. Are they still together?
No, sir. They were actually meeting up that day to sign divorce papers.
Oh, I see.
So they have been separated. They don't have any children.
Okay.
The only reason he has to communicate with her is to finalize the divorce, which to my understanding still has not been done.
All right. So she requested no contact?
Yes, Judge. But if they have to, state would be amenable to no threatening.
2 years, almost, since this happened. So I had to believe there's been some type of contact since then. Okay, I'll order no threatening. So, Ms. Garcia,
Yes, sir.
it's on page 11, Martinez Delgado.
Yes, sir.
So, Mr. Delgado, the court's going to order while you're on bond, you're not to threaten, harass, or assault Gamboa Francis. You may speak to her, you may contact her, email, text, whatever. Just don't threaten her, harass her, or assault her. You will be prohibited from going over to her residence, wherever she may live. Don't go to any residence, okay? And you will also be ordered, sir, not to possess any firearms or any weapons. These conditions of bond are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, we are going to reschedule your case to allow your attorney time to gather all the evidence that he needs. On your next court date, sir, you do not have to come to court. Your attorney will let you know if and when it's necessary for you to return to court. All right, sir. Do you have any questions on anything that I mentioned to you? Okay. Okay. Just a couple things. You have any questions?
Yes, sir.
All right, sir. Right behind you, the table, my pre-trial officer, go with her. Signs conditions, have a seat. We're gonna reschedule your case. And just get a court date from my coordinator.
Yes, sir. Thank you, Judge.
Thank you. You're welcome.
Yeah, it was running 2020.
Millie, on page 2, Barrera Ernesto, court appoint.
Yeah, yeah.
Yes, ma'am. Hey, you're welcome. Yes, ma'am. How are you?
Good, how are you?
I'm good, thanks.
I have a Spanish arraignment on Ms. Ventura Davila.
Got it right here. All right, let's call her Francia Ventura Davila. Now, I haven't heard PC on this. Would you like the court to hear it?
Yes.
Okay. And Ms. Anthony, this is on Ventura Davila.
Yes.
CFSGI. On page, yeah, it's on page 19.
Okay.
Page 19, if you need the cause number. You are Francia Ventura Davila. You're here with your attorney. I just wanted to inform you that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you are being charged with. We're going to talk about any conditions of bond that the court may impose, and then we're going to reschedule your case. All right, Ms. Anthony, whenever you're ready, you may proceed.
Yes, Judge. On 5/5/2025, officer is dispatched to a failure to stop and give information in Harris County, Texas. Complainant told the officer that someone had hit his vehicle while parked. Complainant did not see who, but got video footage from a neighbor. Video showed vehicle and license plate of defendant's vehicle. Officers went to address listed and spoke to defendant. Defendant admitted to being involved in the accident and stated she was distracted. She told officers she got scared and left the scene. Damage was $2,000.
Any response to procedure? Okay. All right, Ms. Davila, the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of failure to stop and give information. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. So what we're going to do this morning is the court's going to order some conditions regarding your bond. Ms. Garcia,
Yes, sir.
it's on page 19, Ventura Davila.
Yes, sir.
All right, Ms. Ventura Davila, there is a person by the name of Eddie Gonzalez that's accusing you of this offense. I have to believe you do not know who that is. Okay, so the court is going to order that you do not have any contact with Eddie Gonzalez. Do not call, text, email, no contact whatsoever. Secondly, the court's going to order that you are prohibited from possessing any firearms or any weapons. These conditions of bond are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. we are going to reschedule your case to allow time for your attorney to gather all the evidence that she needs. On your next court date, you do not have to come to court. You let your attorney take care of your case. She will let you know if and when it's necessary for you to return to court. All right, do you have any questions on anything that I mentioned to you? Any questions? All right, right behind you is my pretrial officer. Go with her. Sounds good. Let's just have a seat. We'll reset your case and just get a date. You're welcome. Yes, ma'am. Thank you. Thank you, you too. Yes, sir. Good morning.
Morning.
What you got this morning?
A couple of custodies at Riverview.
What's the last name?
Last name is Brown.
Brown. Let's see here.
Yeah.
In custody?
Yes.
All right, let me see here. Oh, Tisha Brown. Let me see. DWI.
Yeah, you do.
Things are kind of back to where we don't get a personal bond.
I don't understand. She's only got $100 bond and it looks like, yeah, no, it's kind of funny.
I don't see the equal bond.
I wonder, let me look at something. Looks like she got arrested yesterday.
Yeah.
I wonder if she's in processing.
She got here.
Miss Anthony.
Yes,
Do you
Judge.
see this case,
Yes.
Tisha Brown?
Yes, Judge.
Do you see that if she has anything else pending county besides Harris?
Yes, I'm looking right now. It looks like she was on a DUI probation, but she should have been off of that in 2022.
Back in session, you may be seated.
Okay. So, Mr. Jackson, I've considered your argument, and this is simply the wrong witness, so I'm not permitting that line of testimony for that. So, all right, I think the jurors are on their way.
Please rise for the jury. Court is in session, please be seated.
Go ahead whenever you're ready.
Thank you, Your Honor. Sergeant, I'd like to move to a different area. At some point during the course of your investigation, you and Michael Proctor interviewed Chris and Julie Albert, correct?
That's correct.
That was at the Albert residence, the Chris and Julie Albert residence, is that right?
Yes.
On or about February 10th, 2022?
Yes,
Does that sound right?
it does.
Okay. At any point before or during that interview, did Michael Proctor discuss with you a previous relationship that he and or his family had with Chris and Julie Albert or their family?
Yes, as we're walking up to the door, he stated that he knows them from he knows of them from around town and through friendship.
Did that cause you any concern that the case officer that had been assigned to the case, dealing with, obviously involving the Albert family, had a pre-existing familiarity or relationship with any members of the Albert family?
Yes, I followed up asking him if he hangs out with these people, how well he knows them. And he stated that he does not hang out with them. They're not his friends. He just happens to know them through people in town.
Did he tell you any specifics about communications he had had related to Chris and Julie Albert?
No, he did not.
Did he tell you any specifics about communications Michael Proctor had with his sister as it pertained to Chris and Julie Albert?
No.
Did he volunteer any information about the relationship that he might have or his family might have, including his wife, with Chris and or Julie Albert?
That information did not come up.
Did you ever later learn, now I'm taking it outside of your conversation with Michael Proctor, did you ever later learn about friendship or connection that he and his family, Michael Proctor's family, had with Chris and Julie Albert or the Albert family?
I've learned of accusations. I don't know the extent of how familiar they are.
What accusations have you learned?
Through trial or through court proceedings.
Right, what are they? Give me the nature of what you've learned.
Objection.
Sustained, we need a time frame.
Sure. When did you learn of these, of this information?
That was July of 2023, I believe.
And what were the circumstances in which you gained this knowledge? What did you learn about it?
There were accusations that Michael Proctor had familial friendship with these individuals, but the accusations were not factual.
Did you learn any specifics
Of
of the allegations? Did you use the word allegations? Or I think you used the word accusations.
yes,
Were there any specifics?
there were.
You just said that what were some of the specifics?
Objection.
Sustained.
Well, by the way, did you say that you learned of these accusations during the last proceeding in this case?
Not the last proceeding. I
Or a
said
prior proceeding in this case?
it was through court proceedings.
Okay, how did you learn that specifically, Sergeant? Did you watch some of the proceedings? Were they televised? Did someone report it to you? What were the circumstances?
I was present in court.
This was what year? 2020, 2023.
Yes.
And did you take any action to investigate further the accusations that you said came up in 2023?
No. Well, yes, I did. Yes.
Okay, what did you do in that regard? What were the accusations and what did you do to investigate?
The information had been learned and that it was not factual. So
Okay, you're using the word information. Help me out. Details. What'd you learn?
there was claims that
I object.
Sustained.
May we approach, Your Honor?
Yes.
Hey. But a lot of the stuff that he could get in through Proctor, he's getting in through him. So I'm questioning if the state is really going to call Proctor to the stand, because they've already put it. I'm sorry, if the state Commonwealth, if the defense is going to call, because they've already put in front of the jury that 1, he doesn't work there anymore. 2, he did some crazy stuff, and 3, of course, he was the lead investigator on him being the lead investigator on the trial. So now I'm kind of questioning strategy here, if they are truly going to call Proctor or not. Yeah, Brennan don't plan on calling him at all. He want to just go around and act like Proctor don't exist. So, but at the same time, like I just it kind of make me feel like, at the same time, it kind of makes me feel like you should call him, because why are you hiding this terrible witness? I got to give me a new mouse, y'all. So I apologize for all of our little screen share mishaps. I did order a new one today, so hopefully it'll be here. Them kids. They I don't know. They didn't gave the mouse to D Woods girl, Marley. They didn't gave the mouse to Marley. Marley then took the battery out of it and the USB. I don't even know how she got the USB piece out, because that mug be tucked in there. But my mouse just don't even work. So I'm having to use the little pad to do stuff, and it's different. Lieutenant O'Hara testified about things regarding Proctor also. Yes. So that's what I'm saying. Like, I'm wondering if the defense is saying, well, will we do good enough on these witnesses? Will enough witnesses go in our favor to where we don't have to present a case, to where we can bring enough reasonable doubt? And I think a good attorney would do that, right? You'd at least set it up in a way that would allow you to not have to put on a case if you don't, you know what I mean? If you don't need to. And honestly, the way that the case is being presented, to the facts of the case, the good and the bad, all still go in favor of Karen. So curious.
Final question, Sergeant. I think I asked this, but let me make sure I'm clear. Your interview, along with Michael Proctor, with Chris and Julie Albert, was February 10th, 2022, correct?
I believe so.
Okay.
I'm not certain on that, but I believe it was.
Okay. Well, let me just clear that up real quick. Would it refresh your recollection to look at your report?
Yes, absolutely. Thank you.
Does that refresh your recollection, Sergeant?
Yes, sir.
What was the date?
February 10th.
Thank you. Okay, I want to move to back to Canton PD. Did you at some point recover some videos or a series of electronic data that purported to be videos from Canton PD in furtherance of your investigation?
Yes.
And to whom did you deliver these videos, and whom were they requested by?
The initial request was by Michael Proctor. I delivered them to him.
Okay. Since that delivery, have you seen these videos?
Yes, I have.
Okay. Your Honor, I'm holding a flash drive that I'd like to have, with the court's permission, I'd like to have marked as next in order for introduction, but I'll play the first couple of seconds of it and just establish the foundation first with the court's permission.
Have you shown it or discussed this with Mr. Brennan?
I just discussed it with Mr. Brennan at the break.
What's the Commonwealth's position? I have no idea what it is.
Sure, we can mark it. Yes. Mr. Brennan said he'd like to review them before they get entered into evidence. We can mark it for ID for purposes of this examination.
I don't expect I'll object. I just want to review.
Okay, so we'll mark it for identification, please, Madam Court Reporter.
Exhibit GG for identification.
Just to establish the foundation so we know what we're talking about, did you see on some of the electronic devices that you picked up in furtherance of this investigation video of somebody outside? Now we're the outside cameras or outside camera view at Canton PD at about 1:30 in the morning on January 29th, 2022.
the digital video, one of the collection items. It wasn't a device. It was, well, I guess it is a device, but the digital storage that was collected had video from external view of the PD. I do not remember specifically seeing an individual, but
Okay.
I did
Do you
review
remember
it.
being of the parking lot area, at least one of them, one of the clips being of the parking lot area outside Canton PD?
I don't remember seeing outside parking lot. I'd have to see it.
I understand. Do you remember another clip being of the outside Sallyport, there's a pedestrian door? Not the big roll-up door, but a pedestrian door, someone going in and out of the pedestrian door?
I know the view you're talking about, but specifically what you're saying, I would have to see the video, tell you if I saw it or not.
And I'm asking a couple of these other questions. I think I may know what the answer is. There's another, do you remember another video being an internal corridor, looking down a hallway and seeing someone walk up or back?
Yes,
Do you
yes,
remember that one?
I do.
Okay, and then one on the outside, again, sort of passing from right to left, may not be intended to a parking lot, but at least an outdoor view of someone moving from frame right to frame left across the camera angle.
I don't remember that.
You do remember that all these videos, I just mentioned 4, we've talked about 4, these videos were from January 29th, 2022, around generally 1:30, 1:45, 2 o'clock in the morning?
I'm sorry, I don't remember the exact time and date. I just remember seeing the file and reviewing it.
Do you remember Mr. Proctor asking for video attendant to January 29th? At least can we narrow it to that date?
From Canton PD?
Yes.
Yes,
Okay.
yes.
So these are all from January 29th, 2022. You just don't remember the specifics of them. It's been too long since you've seen them.
I don't know when each video was collected and then reviewed.
Okay.
Exactly.
With the court's permission, well, may I have just a moment to confer with counsel?
Okay.
Your Honor, with the court's permission, I'd ask that what's been marked as GG, at least the first video, be published for the jurors.
All right, so there are 4 videos on this flash drive?
One video, 4 different camera angles as it's set from the one video.
Are you ready to see this now? I thought you wanted to review it.
I'll agree, and if I have a problem, I'll put it. No problem.
All right, so for the first one, the first camera angle?
Correct.
Okay.
It's one video, but 4 different angles.
All right, we just have to keep a record. That's why I'm
Understood.
asking all these
It's a little
questions.
complicated, I get it.
All right, we can do that.
Thank you. And this is, Your Honor, just for the record, actually, let me do it this way. Sergeant, would you agree that we can call this the rear lot main side at Canton PD, just for identification purposes?
Sure, if you'd like. I don't know which side this is, so I can't argue with you about the location. So
Okay.
I'll agree with you that we can call it that.
Great. It looks like a parking lot. There's cars.
Yes, yes, sir.
Okay, just for purposes of, so it doesn't get complicated, we'll call this rear lot main side. That doesn't mean anything unless you adopt it. So just for identification purposes.
Thank you.
If we could move to runtime 1:26:32. Okay, with the court's permission, may I play it at this point?
Okay.
Thank you. Stop. Did you see a car pass in front?
Yes, sir.
Okay. What kind of car did that look like to you?
It looked like a 2-door Jeep Wrangler with a plow on it.
Okay, let's go ahead and play it. Okay, stop. Sergeant, did you, during the course of your investigation, learn whether or not anybody associated with your investigation had a 2-door Jeep Wrangler with a plow on it?
Yes.
Who is that?
Mr. Brian Higgins.
Okay, thank you. Let's go ahead and play this. stop. Sir, do you see a person who appears to have alighted from the car,
Yes.
from the Jeep? Sergeant, if you could turn your attention to the screen on the right. Does that appear to be the location of the person that you're describing?
That's the individual that came out of the vehicle, yes.
Okay. I know it's super blurry. You may not be able to at this point. Do you know who that is?
I do not know.
Okay. Let's go ahead and play it. Okay, stop. All right, did you see the person walk off the screen?
Yes.
Did it appear that that person had something in his or her hands?
Possibly, yes.
Okay. May I have a moment, Your Honor?
Okay.
Thank you, Your Honor. If we could play the second clip on this same GG. Before this is played, Sergeant, do you recognize what's depicted in this photograph?
I do not know.
Okay. Let's go ahead and play this. Stop. What do you see on the video at this point?
An individual crossing the frame with a couple of cars parked, one of which has a plow on it.
Does it look like an exterior video?
Yes.
Does that appear to be an exterior video if you don't know exactly where, an exterior video of Canton PD?
From the facilities, yes.
Okay. And describe the person that you see in the foreground at the bottom of the screen.
Appears to be wearing a black sweatshirt, a hooded sweatshirt.
Larger in stature, smaller in stature, can you tell?
I'd be speculating because there's no comparison, but possibly larger. I don't know.
Okay, let's go ahead and play it. And that's it for that. Your Honor, if we could play the next video. By the way, can we agree before we move off of this, just for identification purposes, can we agree to call this rear lot cruiser side as opposed to rear lot main side, just to keep them separate?
Same as last time. I'm not aware familiar where that camera is, so I cannot argue with you nor adopt. But if for identification purposes only, we can agree on that.
Can you see from where you are, and I know the answer to this, can you see from where you are the timestamp on the bottom of this?
No.
Your Honor, with the court's permission, it's very, very small. Is it possible to ask the witness to adjourn from the witness stand just to get close enough to see if you can read the...
You can't increase the size of it?
Maybe we can. I'm not the tech guy. Mr. Wolk? Magic. Wow. I didn't even know he could do that. Okay. Can you read that?
Yes, it says rear lot cruiser side.
Okay. What about the time?
The timestamp reads 1:27:41.
Do you see a date?
Yes.
What is that date?
1/29/2022.
Thank you. This was my fault. Your Honor, if we could move back to rear lot main side, I'd like to do the same thing. I failed to ask for the time and date on that one. Mr. Wolk, if you could, please. Is it possible to see from there the time and date?
Yes, the time is 1:27:32 a.m. and the date is 1/29/2022.
Thank you. Okay, if we can move to the third clip. If we could start, Mr. Wolk, by enhancing with the court's permission the time and date, let's just start with that. Do you see what the timestamp designates this camera angle to be?
It appears to be church side. And I can't read the third word there.
Exterior.
Oh, yes, exterior. Sally Port.
Okay, and if you could tell the jurors what you see in terms of the time and date.
The time is 1:27:43 a.m. and the date is 1/29/2022.
Thank you. Mr. Wilk, if you could play that with the court's permission.
Okay.
Stop. Do you see a person in that video?
I do.
Although it's somewhat blurry, can you describe that individual for us, please?
Individual wearing dark clothing, possibly. That's the best I could do, really.
Okay. Does it appear, given what you've seen in terms of the time of the main side, cruiser side, and now this exterior church side, does that appear to be the same person moving through on the outside of Kenton PD?
It does, yes.
Okay. And what are we looking at here, by the way? What is this door he's about to walk into?
I'd be guessing. I was never present on that side of the Sally Port.
Understood.
I don't know.
Let's go ahead and play this. Okay. And for the final clip. If we could go down to the timestamp and date. A little bigger, Mr. Wilk, if you could. Can you see what that is designated as, that camera angle?
Yes, it says first floor corridor, and the time is 1:28:03 a.m. on the 29th of January, 2022.
Okay. Is this the corridor version or video that you did have some recollection of?
Yes, this is, yes.
Okay, if we can go ahead and play this. Stop. Do you recognize the person in this video?
It appears to be Mr. Brian Higgins.
Okay, and what is he wearing? Describe it for the jurors.
Black sweatshirt with some sort of logo on the front. It appears to be blue jeans and shoes with a white trim.
And is the hood up or down on the sweatshirt?
It's up.
Okay, let's go ahead and play this. May I have just a moment? Could you pause this, Mr. Wilk? Can you make note of the time as it's paused right here?
Do you want me to say it again or
Yes,
write
sir.
it down?
Yes, sir.
The time is 1:28:16 a.m.
Okay, and if we could just continue playing this video. It is playing. Stop. Now, if you could take a look at the time now. Okay, what's that time?
1:29:42
Okay.
a.m.
And if we could go ahead and go forward. Is it still playing, Mr. Wilk? Okay. If we could take a look at the time one more time.
Now it's, you want me to say it?
Yes, sir.
1:34:12 a.m.
And in the time, just so the record's clear, in the time between you saying 1:28:16 to 1:34:12, 6 minutes has not gone by, correct?
Just under 6, I believe, yeah.
Well, 6 minutes for us in real time.
Oh, in real time, yeah, no.
It is not. So it
Sorry.
appears that the camera jumped, or the time jumped.
The time difference from what was displayed is approximately 6 minutes, yes.
Okay, which is much further than, much longer than the time we've actually been looking at the video, correct?
That's correct, yes.
Okay, so it appears that it may be motion activated and it just jumped.
That's a possibility, yes.
Okay,
yes.
let's go ahead and continue playing this. And stop. Do you see someone in the screen now?
Yes.
And one more time, I know this is laborious, one more time if we could clock the time. Can you see that?
No, it's really blurry for me.
There we go.
Yes, now I can see it 1:34:15, if I'm not mistaken, AM.
Okay, fair enough. And let's go ahead and play this all the way through. Okay. Who did that appear to be walking away from the camera in this shot?
I'm not certain. I would be suspecting or guessing if I gave you an answer, but I'm not certain who that is.
As best you can determine, does he have the same stature? I know you can't see his face. Same stature, same clothing, jeans, shoes with white stripe around it, dark hooded sweatshirt. Does he appear to be the same person as Brian Higgins?
It does appear that way, yes.
Okay. Is that it? Okay. One more clip that you look at on the same GG device. Okay. What do you see in this video?
Appears to be the church side sally port, and an individual came out of the door.
Okay. Can we highlight the time, please, or increase the sound? What time do you see there?
1:34:40 AM.
Okay. If we go ahead and play this through. Pause. Does it appear from this video that the person has anything in his hand?
I'm sorry, can you play that again? I wasn't looking at the hand, but
Sure.
I really can't tell.
Okay. There should be another video of the rear lot cruiser side. Let's take a look at that. Pause. What do you see in that video?
It appears to be an individual wearing a black beanie hat, black dark colored sweatshirt with some design on it, and something illuminating by his face.
Can we enhance the time, please? What time is that?
It says 1:34:53 in the morning, AM.
And if you could move the screen over to the individual. Mr. Wolt. Does that appear to be the same person?
It could possibly be, yeah.
And does it appear as something in his hands up to his face, the right side of his face or ear?
Yes.
What do you think that is?
It's consistent with a cellular device, possibly a phone or a tablet.
Okay. If we could move on, please. Play that through. And I believe there's one more video. And Your Honor, this one is a little longer. This is about 10 minutes.
Okay.
With the court's permission, I'd like to play this through. Okay, stop. Do you see a person in the video walking from screen right to screen left?
Yes.
Did that person appear to have something in his right hand?
I can't tell. I can't see his right hand.
Okay. When he first walked into the screen, could you tell?
I couldn't know. I'm sorry.
Mr. Wolf, could we back that up with the court's permission, about 2 seconds? Stop. Did it appear as something in his hand?
It's a possibility, yes.
Okay. And just for, I'm going to ask you for 2 times when we start and when we stop. What's the time on this video at this point when he walks into frame?
1:35 and 8 seconds in the morning AM.
Okay. And let's go ahead and play this through. Pause it, please. Sergeant, at this point, do you see a person walking into the frame into the video from frame left to frame right?
Yes.
Okay, go ahead. Can you pause it? Did you see something happen with the vehicle next to the Jeep in the last few seconds?
Yes.
What was that?
It appears as though the headlights are activated.
Okay, let's go ahead and play it. Okay, pause it. You see a person that is walking from screen right to screen left in the middle of the screen?
Yes, he just, or she just appears to have closed the door on that vehicle next to the plow.
Okay. And walking toward which vehicle?
The one on the furthest on the left.
Okay, from what you've seen, Sergeant, that you said he or she, does that person appear to be consistent with the video that we've seen in other particulars of Brian Higgins?
As far as I could tell from here, the individual accessed Brian Higgins' vehicle, so I'd be speculating with the whiteout conditions or near whiteout conditions. It's tough to tell.
But no reason to believe that's anybody other than Brian Higgins accessing Brian Higgins' vehicle?
No,
Okay,
no.
let's go ahead and play it. And what do you see Brian Higgins or that person doing now?
They accessed the vehicle on the far left.
Okay. And where's that person going?
Now they're accessing the Jeep Wrangler.
Can you pause it? Where does that individual appear to be now in the video?
Last I could tell, they might be by the Jeep Wrangler.
Before that person got to the Jeep Wrangler, is he standing by the vehicle on the far left? SUV or truck?
It appeared that way, but with the heavy whiteout snow that night, I can't tell exactly what they were doing.
Did you see anything in his hand, like a bag or a satchel or a duffel bag or something when that person walked from this vehicle over to the Jeep?
I did not notice, no.
Go ahead. Now, has that person walked off screen to the left?
Yes, sir.
Okay. you see that person entering screen from screen left?
Yes.
What did you see the person do?
They were carrying possibly like a snow broom, walking from left to right.
And what do you see happening now?
The Jeep Wrangler's leaving the spot it was parked in.
Okay, we can take that down. Oh, I'm sorry. I failed to ask you the time. I promised I would do it and I forgot again. Can we look at the time real quick?
Yes, the time for the rear lot main side is 1:45:52.
And it appears that's the approximate time that the Jeep Wrangler drove off.
Approximately, yes.
Okay, thank you. In are you friends with Brian Higgins?
I am not.
Do you know Brian Higgins?
I know who he is, yes.
Have you ever socialized with Brian Higgins?
Like out on private time?
Go out, have a beer,
No.
see him at a bar. Hey, Brian, let's grab a beer. Nothing like that?
No.
How long have you known Mr. Higgins?
I'd be speculating. It's before this case. He was a law enforcement individual that worked in the area. So I've had cases where he assisted on and that I've assisted on.
Would you consider yourself to have a professional relationship with him?
I knew who he was. So yes, I would consider it a professional relationship.
But you would not consider your relationship to have gone over to the personal relationship? You don't
Not at all.
socialize, do any
No.
private
No.
get-togethers?
No.
Okay. You would agree that this video pretty clearly shows, at least at one point, around 1:34 a.m., Brian Higgins was on his phone.
Is that the one that he has the device by his face?
Correct.
It appears that way, yes.
And just to be clear, when you interviewed Mr. Higgins, he did not volunteer to give you his phone, correct?
He did not volunteer, no.
And you didn't seek his phone through a warrant or any other mechanism?
I did not know.
Do you have any personal knowledge as to the status of that phone as we sit here today?
The one that he got the extractions from?
Correct.
No idea, no.
I want to shift gears to another series of videos. Last year at another proceeding, you were asked about a couple of videos from the interior Sallyport garage at Canton PD. So now we're going to move to the interior. You remember those series of questions and answers that you gave?
Generally.
Okay. You were asked at another proceeding to describe when the SUV, Miss Reed's SUV, first arrived at the Sallyport garage around 5:30 or so, correct?
Based on my recollection of it first arriving or what we were reviewing?
What you were viewing?
Objection to this.
Ask it differently, Mr. Jackson.
Do you remember being asked a series of questions concerning the arrival of the SUV, just in general?
I remember that it happened. I don't remember the exact questions on what my answers were.
And you remember seeing a video about which you were asked questions concerning the arrival of that SUV, pulling into the Sallyport, who was who, what the time frame was generally. Do you remember that colloquy, that discussion?
I remember it taking place, yes.
That was Mr. Lally asking you questions, correct?
I believe so.
Under questioning by the Commonwealth, you were asked whether the video that you were looking at fairly and accurately represented the SUV arriving at the Sallyport garage, correct?
Yes.
And you indicated, in fact, it did fairly and accurately depict the arrival of the SUV at the Sallyport garage. Is that right?
That's correct.
I'd like to ask you a question about that particular video. Do you have any? Your Honor, I'm holding a flash drive. May I approach?
Yes.
I'm gonna have to just pull it up. May I have a moment to consult with counsel?
Paul, the lunch is here. Jurors, you know what? Let's take the luncheon break.
Thank you, Your Honor.
Hmm. Do is have the voir dire right now to see what Sergeant Buchanan knew regarding that line of testimony you wanted to get into. So let's do that now, and then you can all work out the video issues.
Yes. Okay. May I inquire briefly?
Yes.
Thank you. Sergeant, we were talking before the jury left, we were talking a little bit about the conversation that you had with Michael Proctor, either during or just before or just after that first interview with Chris and Julie Albert. What I'd like to ask you is, what information did you have and what did you ultimately learn about their relationship? You said there were some accusations and we never really got to the heart of it. What did you know and what did you do to investigate? Or what did you learn?
What I knew as we were walking up to the door is that he had knowledge of the individuals prior to us conducting the interview. I asked him if he knew them personally. My words, do you hang out with them? Do you socialize with them? He said, no, I do not. I said, are you comfortable doing this interview? And he said, yes. And me being a complete outsider and his supervisor and realizing if there was any impropriety that I would step in and recognize it, report it, and act on that. The interview was conducted without issue and we moved on.
As a matter of fact, one of the things in Trooper Proctor's report, it said the report started with following formal introductions. Did that suggest to you that Trooper Proctor had no knowledge of who Chris or Julie Albert were from a personal standpoint?
Not at all. I believe maybe I wrote the report, or was it him?
Yes, I think it is you. I think it is
Yeah. So I.
Mayor Coach.
Yes.
Just so you have it.
Thank you. Yeah. Since I authored the report, I wrote following formal introductions since I've never met them before.
Okay, so that was more attended to you than to Michael Proctor.
Correct.
Okay, but the report does say we introduced ourselves, basically. Following formal introductions.
Greeted, but I had formal introductions to them. I've never met them before in my life.
You said that subsequently you learned about your word accusations that had been made concerning possible relationship between Michael Proctor and the Alberts. What was that information that you learned?
When was it? I need that.
When did you learn it? I thought you said 2023, but I could be wrong. When did you learn that?
It was I believe, during the July motion proceedings when you guys had pictures up of children.
July of what year?
I believe 2023.
Okay. And what was it that you learned in July of 2023 about the potential?
The accusations?
Yeah.
That those were Albert's or McCabe's kids in the photograph with Michael Proctor?
Okay. Did you ever learn about personal communications that Michael Proctor or his wife may have had with any of the Albert family, including Julie Albert?
Ever?
Ever?
Yes.
Okay. Tell me when you learned that and what you learned in that order.
Well, Michael Proctor had communicated with those individuals, Elizabeth Proctor and communicated with those individuals due to the harassment that they've sustained.
Okay.
So with the crazy behavior that's been, imposed on them, and the torturous harassment that they've endured, the traumatic experiences they've had to live through, they've communicated. So I've learned about that. Yes. I was taking in all of that evidence, hundreds and pieces of evidence that I've archived in order to.
Go ahead. In order to
investigate it.
Okay. You're talking about Elizabeth Proctor well after the fact of the interview and the incident in 2022. That's what you were just describing.
It was after the harassment started, yes.
Which is well after January 29, 2022, correct?
January 20, yes, it is.
Okay. I'm asking about information related to a relationship prior to January 29, 2022. Did you ever learn about a pre-existing relationship that may have existed between the Proctor family and the Albert family before January 29, 2022, and maybe a couple of days after?
All I know is that there was a relationship explanation provided by Mr. Lally during one of the motions, and it was like 6 degrees separated by individuals residing in the community, living in the community, raising their kids in the community, working in the community, so making them community members and having relationship within that. I don't know the extent of those relationships.
Okay. Did you, during that hearing where you